So, Renato, how embarrassed should the Trump administration be with this recent decision in the Wilmer Hale case?
Eh, it's complicated. I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And I'm Asha Rangappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm a legal and national security analyst.
And we're here to help you understand topics that can't be boiled down into a soundbite or a skeet. Well, Asha, this decision got so much attention.
Yeah.
Tons.
For good reasons, and then for some cringy reasons, maybe.
Maybe. It's interesting. It sounds like you may have the same opinion as me as certain aspects of this opinion. But this is the judge's opinion regarding one of those law firm executive orders.
That's right. So this is Wilmer, I forget the full name of this.
Wilmer
Cutler, Pickering, Hale, and Dorr, typically shortened to Wilmer Hale.
Correct.
And this was an executive order that was targeting them, and they caught the eye of Sauron, aka the White House, because among other things, that was the law firm where Robert S. Mueller III went to work at one point. I think both before and after he was special counsel, I believe.
I've heard of him. Yeah.
You've heard of him. Yeah. A little flashback to season 1. And the firm has represented a number of clients, including Democratic candidates, I believe even Hillary Clinton and Democratic Party and some of its litigation. So, yeah, Trump was big mad at Wilmer Hale.
Yeah, I mean, Wilmer Hale, also shout out managing partner Wilmer Hale is a classmate of mine, Anjan Sani from Yale Law School. But Wilmer Hale is a firm, more litigation, white collar enforcement focused firm. We've seen those firms like Jenner and Block, Wilmer Hale, be more likely to fight in the Sussman Godfrey. Some of those firms, we've talked a little bit about that in the past. And Wilmer Hale here, it actually hired a big conservative lawyer, Paul Clement, to represent them in this case. This was an order that was remarkably similar to the order that Paul Weiss was facing before they cut a deal. And one of the interesting, I think, parts of this decision, Asha, is the judge considering whether or not he should consider the order as a whole or whether or not he should be looking piece by piece. Because often when you're looking at governmental action, if you're a judge, you kind of save the government in a way by looking at, let's say, a statute section by section or executive order section by section. So this way, maybe sections, 1 through 13 are unconstitutional, but section 14 might be constitutional, something along those lines. You could save a part of it. The judge here considered it all together for a number of reasons and ultimately basically threw out the entire thing.
Right. So it has 6 sections, and it also had a fact sheet that this is the executive order, has 6 sections and a fact sheet that's attached to it. And the different sections address different things. So like one section was about security clearances and the other was about federal contracts. So it had all these different pieces that the judge basically said that the administration is treating this like a whole. And he refers to the Paul Weiss executive order and how after Paul Weiss made a deal that the Trump administration pulled the executive order back in full. In other words, they weren't like negotiating on different points of it. It was sort of an all or nothing, order.
Right. I think that was one of the things that the judge relied on, heavily to reach that conclusion. Another was, of course, as he pointed out, Wilmer Hale was the one who filed this lawsuit. Whenever you're the one who files the lawsuit, you get to kind of tell the story. You get to pick the location, the court you're going to. You also get to sort of frame what the lawsuit is about. And here Wilmer Hale was challenging the whole thing, saying it was read as a whole. And I think the judge also, viewed this order as one whole thing, and that kind of referred to itself as all being done for a singular purpose from the judge's perspective, retaliation for the viewpoints and that Wilmer Hale had, as well as some of the advocacy Wilmer Hale did and some of the individuals that the partners of Wilmer Hale chose to associate themselves with.
Yeah, the Wilmer Hale, I can't even say this name, Wilmer Hale, was alleging violations of the First, Fifth, and Sixth Amendments to the Constitution. And even though the Trump administration wanted to kind of treat it in these different parts, even the administration, even the Trump lawyers couldn't really articulate, you know, where the complaint was addressing specific sections. In other words, you know, it wasn't clear that the different claims being made could actually be neatly compartmentalized. So yeah. So anyway, the whole thing is considered, and he basically strikes the whole thing down.
Correct. And, you've mentioned these different amendments of the Constitution, but essentially, I think the judge, just to sort of break it down a little bit for people, I mean, I think the judge was agreeing with Wilmer Hale that they were targeted based on viewpoints that they had, certain pro bono causes, for example, that they advocated for. And they also, I mentioned freedom of association a minute ago. Even if there's reasons why one person may have done something that could draw the ire of the administration, not every partner of Wilmer Hale, current partner certainly, was all in the same boat, but they were essentially being targeted simply because they decided to do business with other people, right? Essentially, they decided to associate themselves into a partnership, and that alone was enough to loop them in under this order. And so really, I mean, I think, Asha, you could have probably found a number of other constitutional or legal provisions that this order violated, but these are very strong because they're all kind of very core constitutional principles that the courts typically construe very strictly against a governmental action that violates them.
Yeah, and I thought it was interesting that the First Amendment claims were further broken down into actually different activities and rights that you have under the First Amendment. So there was the retaliation for someone exercising, or for the firm exercising its First Amendment right, because presenting its views in court is considered a form of expression. And then there was the viewpoint discrimination, because when the government, to the extent that the government is able to put any limits on speech, what it cannot do is discriminate on the basis of the viewpoint that is expressed. In other words, they can't say this, it's okay to do this, but it's not okay to say this. But I thought the right to petition the government was a really interesting one, as something that is so fundamental, and it gets to the heart of what lawyers do, that you have the right to petition the government for grievances. We use lawyers and the legal system to do that. And so if you effectively paralyze and punish a law firm for engaging in that very activity, that is very much a direct First Amendment violation.
That's right. And this is a situation where I really think, we've talked about this, I think, on prior episodes, Asha, where the Trump administration shot themselves in the foot by going and acting hastily, quickly, without really thinking through and carefully crafting their actions. In other words, you could imagine a very sinister, clever executive order that finds little violations here or there, takes certain activities to burden Wilmer Hale based on, very, carefully targeted requests and very specific violations. Here, I'd say the executive orders were so ham-handed and could so obviously be painted as retaliatory that I thought it made the court's decision rather easy for the court to make.
Well, I don't know. I might push back that there is even any form of executive order that could be tailored in such a way that would pass legal scrutiny, because one of the claims one of the legal arguments the court makes is this separation of powers argument,
Mm-hmm.
right? This idea that it is actually exclusively in the purview of the courts and the judicial system to sanction lawyers, and, for whatever, for violations of their professional duty, or for, bringing frivolous litigation or whatever. And that what the Trump administration is purporting to do is punish them for that type of conduct. And that is actually infringing on the prerogatives of the judiciary. I thought that was a really interesting argument, because that goes far beyond, just the First Amendment piece. That's just basically saying stay in your own lane.
That's right. And look, there's just a lot of different ways to attack the executive order. I guess my view is that you could have an agency, hypothetically, looking at their hiring practices or something very narrow that focused on that and created a burden on the firm and so forth, that didn't reach this far. I think this executive order so baldly unconstitutional, so obviously retaliatory, so expansive in scope. One could imagine something that was done by some agency that was a little bit harder to look quite so it didn't paint with such broad of a brush. But I think that's a good thing for Wilmer Hale, just like it was a good thing for Harvard, that the administration was so obvious in what it was trying to do there.
Well, and with the First Amendment claims in particular, when you have an actionable First Amendment claim, the government's burden is very high. It is not just that they're allowed to just have any reason. When the government abridges First Amendment activity, even if it's they believe there's a reason to do it, it has to be narrowly tailored to meet a compelling government interest. And here, I mean, there's no government interest beyond the fact that just Trump doesn't like this firm, and it's obviously not narrowly tailored to any specific thing, like with the revoking of the national security clearances, or the revoking of the security clearances. The judge says, they really haven't articulated how this firm is a national security threat beyond just kind of concluding this. And I think, to your point, to the extent that the executive branch might have some power, whether it's law firms or, Harvard or whatever, it usually first takes the form of an investigation by an agency. You don't just suddenly issue an executive order punishing people for factual conclusions that you've come to without any kind of fact-finding process and adversarial process that allows the person or entity that you're investigating to be able to come forward with their own evidence and things like that. I mean, it goes back to this whole due process issue, right? So, in the context of universities, for example, and I know this because I work at one, if there are civil rights violations happening on campus, the Department of Justice, the Civil Rights Division can investigate that. The Department of Education can investigate it under things like Title IX or Title VI. And once they do that, then if they find actual violations at the end of that investigative process, they can fashion actual remedies that address those violations. So it's just a farce all around, right? I mean, this is, even if there were some reason for the executive branch to be looking at particular law firms for engaging in racial discrimination, the vehicle to address that is not an executive order.
Right. Well, an investigation, just to play this out a little bit, would also place a significant burden without reaching any conclusions. Like, right, we're just asking questions. We're just sending subpoenas. We're just gathering data, right? But it obviously can create a cloud. It can create massive costs, can pose all sorts of soft costs on a university or a law firm or somebody else. So it's something that, might have been a more problematic for the law firm step for the executive branch to take. Here, like you said, the standards are high. They could paint with a very broad brush, and they did in this complaint. And that's why, of course, the judge engages in such sweeping language, rejecting it.
Yeah. He's basically incredulous in this whole thing. And we know that because he uses a lot of exclamation points.
And when you say a lot, you mean a lot. Like 2 in the first paragraph, 20 something throughout this opinion. It was a little much, in my opinion.
So, yeah, and it's interesting because, in my national security law class, I have my students do papers every week. And one of the things that I categorically ban are exclamation points.
Yeah, if a young associate turned this into me with all these exclamation points, I'd be like, wow, this is like junior high school here. Like let's cut this out. Let's be very measured. If it was a clerk, right, writing a decision for a judge, like why are we doing this? It almost diminishes the
Yeah.
power of the opinion in my view.
Yeah. I mean, I think maybe to do it on one where it's like the framers would agree or whatever, he says something like that, maybe once. But
Poor Joshua, right? Like that was a famous 2-word sentence from I think it was it was in a Supreme Court decision where it's like, decrying, what had happened to a young man or something. That makes sense. It's so shocking because it's so abrupt and so unexpected in the middle of an opinion. But here it's all over the place from the first paragraph on down, and it's just all over the top. And so I think it makes it seem like the judge is trying to jump up and down and draw attention to himself, and he didn't need to. This is a decision that would have drawn a lot of attention anyway. What the administration is doing is wrong, and he could have said that so with words, not with exclamation points. And I would feel the same way if there was like all caps. Like it's the sort of thing that actually it's sort of like a crutch that you use when you don't know how to use language to achieve the same effect.
yeah, it was a little surprising. I'm surprised. I would be actually interested to know how many federal court opinions have used exclamation points.
This many too. Yeah. Not just one, right?
Right, exactly. But nevertheless, fortunately, the actual underlying legal analysis is, I think, very strong. And there are a couple of claims that Wilmer Hale makes that the court rejects. He rejects it's an equal protection claim because he says, that Wilmer Hale hasn't really established that they can't really point to other law firms that are exactly similarly situated as a reference point for them being treated differently. I thought that was really interesting because I thought there are a lot of examples, but whatever. The point is he is being fair here. He's not just a wholesale, finding for Wilmer Hale on everything. But I also felt like the claims are so strong and they're the same ones that Paul Weiss could have made. Like, it just makes you wonder, like, why not just challenge it?
Well, Paul Weiss is a very different law firm than Wilmer Hale. Paul Weiss is very heavily corporate, M&A focused. They do a lot for private equity, and it's a much more profitable firm, probably by 2 to 2x or more of Wilmer Hale. And so it's a firm in which I suspect in internal conversations, I don't know, I have no knowledge, but I would suspect there's a lot of internal discussion and dissension, and there was a worry that the firm would fracture. And people, partners would leave, and it would start a spiral for the firm if they didn't cut a deal. Now, obviously, there's been some recent departures there. And, just this week, 4 partners left Paul Weiss. They're very prominent partners who are, I think would be fair to say, are partners that would fit into the business model very much of Wilmer Hale, who are litigators and enforcement lawyers and so on, have left.
So they were worried that their profits per partner might go down by, from X million to Y million or something. I mean, come on.
Well, they're worried actually that
lawyers to look at something like this and be like, this is such an obvious First Amendment violation. Like, we could just go to court and basically get
I hear you.
unenforceable.
I mean, I think it's also there's a lot of times that clients have really stupid claims filed against them and you just settle them because it's not worth the cost of fighting them. I think the concern was the cost of fighting them
Yeah.
would be so high for the firm and would fracture the firm and potentially have many departures that would have a spiraling cascade effect, is what I suspect. I mean, I don't think they were in a good position. I'm not defending or attacking either of these firms. I'm just noting some of the dynamics, is how I would put it.
I think it's lame.
And so does this judge.
Sure. Exclamation point.
So Asha, we go from a exclamation point laden 73-page decision to a very tightly written 17-page order that is scathing and absolutely takes down the Trump administration for some pretty egregious activity.
Yeah, and equally as angry, but as you said, is more able to express this in declaratory sentences. So this is about the Trump administration's attempt to deport 6 illegal migrants to South Sudan. Now, unlike the people that have been sent to El Salvador, the Venezuelans that were rounded up, and people like Kilmar Abrego Garcia, who committed no crime, and I think now the Cato Institute found that about half the Venezuelans that were sent to El Salvador were not ever convicted of any crime. These were actually 6 violent offenders. And
Correct.
what the government is alleging is we're allowed to remove violent criminals, and if their country of origin refuses to take them, we are able to remove them to a third country. And in this case, the country that they chose was South Sudan, and the court had actually stopped them initially from going to South Sudan. So until they gave notice and an opportunity for the migrants to be heard on whether they had a reasonable fear that they would be tortured in violation of the Convention Against Torture, to which the United States is signatory, if they went to South Sudan. So they are currently hanging out in Djibouti.
Another African country,
Yes.
maybe a little easier to get to, and I don't know, more scenic than South Sudan, on the coast. But it's an interesting thing, right? I mean, this is, I would say, yet another example, as you point out, of the administration spiriting away. Isn't that what it's like an anime movie? Spirited Away, spiriting away, people disappearing. I think we used that as a verb in a prior episode. Disappearing people to another country. And what was remarkable about it is the government did that. The Trump administration did that. Remove these people. And the judge was understandably concerned and was like, okay, there's no due process here. Sound familiar, by the way? Because this was not the
And
first
there's a
time.
civil war raging in South Sudan.
Yeah, it's a place. They're better at basketball. They almost beat the men's basketball team in the Olympics. True story. That's where Luol Deng is from. More trivia for today, for today's episode. But very one of the most is war torn country.
Yeah.
One of the newest countries in the world to break off of Sudan. That is, I think it's fair to say, has a very low standard of living and a lot of challenges. So understandably could use all the money from the United States that it could get. But in any event, here's a situation where we've talked about this in prior episodes. You can't just spirit people away to other countries without giving a due process. We've talked a lot about due process being, the ability to sort of challenge that, in this case, that removal and give it an opportunity to be heard. Here it was whether or not, for example, you might have a reasonable concern about being tortured or something like that in this new country. But in any event, there was a hearing in which the Trump administration was asked about this and basically suggested to the judge that they can provide due process from South Sudan. They're gonna, I don't know, fly rent-a judges out there or whatever.
Djibouti. I thought it was they were
Or
going to do it.
was it Djibouti?
I
Yeah.
thought it was in Djibouti.
In
Yeah.
Djibouti, excuse me. You're going to get a bunch of like administrative judges out to Djibouti to do your hearings there for an inexplicable reason. I don't know why you would rather do it there than like Dallas or something, but in any event, that was what they had offered to the judge. And then they decided 5 days later that they weren't going to do that and that wasn't practical at all.
Well, they suggested to the judge they can do that. And so the judge said, okay, I'll leave it up to you so that I'm not tying your hands. Like, I'm not going to force you to bring them back. And to answer your question on why not do it in Dallas, I think right now they don't want to provide any indication that they can or will bring people back once they get them out. I think
Right.
that's their trump card, right? So actually they got a win where the judge said, okay, I'm going to defer to your, branch and your judgment on how best to do this. But as long as they get an opportunity to be heard, and then they came back and asked for a stay of that order. And this is why the judge is mad, because the judge was like, why are you asking me to stay the remedy that you asked for and that I gave you?
Yeah, I mean, they could have literally had a Zoom or something where these guys were in Djibouti and then they had an administrative law judge in another location or something. There's certainly ways to get that done that would be a lot easier than challenging this. But I think it it it's either that they don't want any limits on their authority, but I think more likely, Asha, that the left hand doesn't know what the right hand is doing. And it really seemed like they didn't even the lawyers in court who were making those representations didn't realize that the administration didn't actually want what they asked for.
That's possible. Or they didn't think that the court was going to grant them that kind of leeway. Like maybe they were banking on the judge saying, no, you have to bring them back, just like they did for Abrego Garcia and these other people. And then they could stonewall and say, oh, we don't have to bring them back, or we have no. I mean, I think it's harder to make the argument here that they can't bring them back, because I think the plane is like sitting in Djibouti, and I think they stopped there and with permission. Like, in other words,
Right.
that they're still in constructive custody of the United States. I don't think there's much question. But yeah, so then they were kind of hoisted by their own petard, as Shakespeare would say, when the judge said, okay, fine, do it there. So it really seems like they are just anti-due process. Like, they are really against this idea, maybe because even if they were to give it even on Zoom to these people, then it is conceding that they can or should give it to all these other people to whom they have denied due process. And I think this is just about never not conceding an inch. I mean, this is sort of they're just drawing a line in the sand. And I think especially with these defendants, I think maybe it's interesting that they picked 6 people that are violent offenders, because I think the blowback from Kilmar Abrego Garcia and the gay barber and all of these other sympathetic people who are like, I have an autistic son or nephew and I have a tattoo about that. People are like, what are you all doing? It's much harder to rally public sympathy for violent criminals. And these people did some bad things. And I think they're kind of banking on maybe this is going to help sway public opinion, or maybe be able to paint judges as being obstacles to removing dangerous people from this country.
Yeah, it's interesting too. We've talked a little bit about venue before. District of Massachusetts, not a good spot. For the Trump administration, First Circuit, Court of Appeals, not the circuit that they would want to be in at this point in time. So if you look at the lineup and who appointed the judges there, so it's an interesting choice of location for this particular suit.
Though they leapfrogged the First Circuit.
So, wonder why.
They've gone straight to the Supreme Court, and they have basically said, what did they say? What was really interesting in their application to the court is these people have never indicated that they're afraid of being tortured in Sudan, like on the day that we told them that they're going or something like that. Like, in other words,
Yeah.
they never expressed any fear. And it's like, well, that's not really the point. Like, you're supposed to have a hearing, but I think they are really doubling down on the fact that these are convicted criminals of violent offenses.
Yeah, and look, the fact that they went to the Supreme Court just shows you that the administration is standing behind this and they want to fight it. It is kind of a hilarious / ironic / sad, whatever, however you want to characterize it, that they're saying these folks haven't alleged anything about that or made any complaints. Of course, they didn't get an opportunity to be heard.
That's the whole point.
Yeah, right. Indeed, right? It's like if we had a hearing, perhaps they would make such allegations at that time. But how convenient, right?
Well, we'll see what happens. The story is not over yet.
Indeed. So, Asha, I am sitting in an uncomfortable wooden chair near other uncomfortable wooden chairs because I am in Colonial Williamsburg.
Well, I don't think that is like something that is a part of Colonial Williamsburg. I think you're just in a kind of a dated hotel, it sounds like.
Okay, fair enough. They don't have a lot of power outlets in this hotel. Is that also just a feature of this particular hotel?
He's trying to give you the true colonial experience. Do they give you like
a water? Do I need like a water wheel or one of
do they give you like a candle and a quill and and some other things? I love Colonial Williamsburg. So you're near where I grew up. I grew up in the Hampton Roads area.
I need to crash the Rangappa residence.
You should crash the Rangappa residence. And so Hampton Roads is about 30 minutes, but I love Williamsburg. We always made our annual school field trip to Colonial Williamsburg. That's sort of where kids in Virginia go. And also, you are very close to Busch Gardens.
Okay. There's one of those in St. Louis. Been to that one. Busch Gardens. It's like a park with like a bunch of animals, no?
Oh, this has roller coasters.
Oh, okay. Really maybe that one had roller coasters too, but there's definitely like a whole animal part of it. I remember that. Like,
no, but Busch Gardens Williamsburg actually has, in my opinion, some of the best roller coasters.
Interesting.
Yeah. So if you have
to talk about that sometime. Roller coasters.
I love roller coasters.
Okay. I used to like them more than the last time I went to. We'll talk about that some other time. What happened the last time I went to ride some roller coasters.
Yeah. So Williamsburg, there's Busch Gardens, and I think there's also the Anheuser-Busch Brewery. So if you're not interested in the roller coasters, you can go check out the brewery. But if you check out the brewery, I would do it before riding the roller coasters, probably. No, do it after riding the roller coaster. Sorry, wrong order. And then also William and Mary is there, which is a beautiful.
Heard of that school? Yeah, heard of them.
And there are actually some really great golf courses in Williamsburg. It's called Kingsmill on the James, and that's where a lot of I bet a lot of your favorite NBA players come there and golf, actually. So
no kidding.
You can get on the links and see some of your
favorite
players.
There may be redeeming part of Colonial Williamsburg after all. Okay,
we won't shame the hotel that you're in because, as I told you, it may be because I think it is part of the official tourist thing. It might be funded by the state. And by the way, I believe Colonial Williamsburg and, the historical, foundations there and stuff have just gotten a bunch of their federal funding pulled.
That's a shame.
It is a shame. But you should go check it out anyway.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.